one of our core values is entrepreneurialism. My kids, they're going to prepare a business plan. Mom and dad die and they're worth about $5 million. It goes outright to the kids at 25, 30, and 35. A lot of my clients are not necessarily bought into the stock market entirely. Okay. And I hope my kids are fabulously successful, but chances are they're going to fail a lot of times.
Hey, what's up, everyone? Welcome to the Wealthy Dentist Podcast. I'm your host, Ward Powell. And if you're a dentist looking to crack the code on how to grow your practice and dominate in this space, then stick around. You're in the right place. Every week, we're sitting down with some amazing dentists who are doing incredible things in their businesses. We're talking about everything from how they keep their teams loyal and dedicated to how they stay ahead of the game in this crazy, fast-changing industry. You'll hear about hacks like using virtual assistants to free up your time, strategies to make more sales with less effort, and even mind-blowing stories about patents and inventions that are changing the industry as we know it. And it's not just about growing your practice, it's also about finding out what works from a clinical perspective. Whether you're just starting or you're ready to scale to the next level, there's something here for you. So buckle up, hit that subscribe button, and let's dive in. So we have again for part 2, attorney Andrew Howell that's going to continue his discussion about, okay, we left off with when I die, I'm not leaving 1 cent to my child. And why? I mean, I know that's kind of like confusing to a lot of people. It's like, oh my God, how could he? How could he? But
Yeah.
I'm going to give you an opportunity to listen to it from another perspective. Andrew, what do you have for us today? And I appreciate you spending this hour with us again to do a part 2 because you are the first. I've never done a part 2 on anybody back to back like I'm doing you because I think this is a serious
Wow.
topic. And like you said, it's been thrown around and used and abused in some cases. And I just want you to help people understand in layman's terms, what does that really mean?
Yeah, I feel honored. I get the second date, and it's pretty quick too. It wasn't that long ago. I was on the first one, so I have to live up to that now. I still see a wide range of what clients want to do, and I'll have the client that just says, like, I don't care. I'm going to give it all to my kids. If they blow it, what do I care? I'm 6 feet under, right? I still have those guys that'll come in and then I have the people that say, I won't give anything to my kids. I'm going to give it all to charity or something like that because I don't want to create trust fund babies and the kids didn't earn it. That second one's never made sense to me. At least in the first one, there's some faith in your parenting, right? You're saying, hey, look, I've done a good enough job that I have strong faith that if I just dump it onto my kids, they're going to do exactly as they should with it. And also, with that strategy, you're hoping nobody ever tries to take it from them. They don't have divorces or bankruptcies or lawsuits that ever come into their life. And very good chance your child's going to have one of those things happen to them and during their life. And just by leaving it outright, it goes and they could potentially have it wasted for those reasons. But at least I still understand that philosophy. I've done a good job. My kids make good decisions. They can do what they want with it. Now, I can get the benefit of both worlds where you can leave it to them in such a way that it's really well protected, but they also control if you have that much faith, but it's not theirs, not available to creditors, not part of their estate for estate taxes, all of those types of things. The second guy, though, who says, hey, I'm going to give it all to charity because the kids didn't earn it. It's hypocritical. I mean, the charities didn't earn it either. Right. And so really it's more about where you're not giving it. Right. I don't want to give it to my kids. I'm afraid of what they would do with it. And so I guess I side more with the first guy. than I do
Yeah.
with the latter.
Mm,
Because I don't have anything against charitable planning by any stretch of the imagination, right? One of our chapters in Entrusted is devoted to families being generous, and families have to have whatever that might mean in your family. It could be a religious charity, it could be your alma mater, it could be the homeless that you want to help, right? Something above the family that the family can put as a centralized goal, right? You anyway, but generosity is a big part of all of that. Um, so anyway, I think you can have both, but and I know you can have both. And so to me, that's what more people are going for right now when they're talking to their advisors, whoever that might be, right? This umbrella, this team that you should have from your, blood-sucking lawyer like me who helps you with your will and your trust, or setting up an LLC in Montana, or an offshore trust in Nevis if you want to go that complex, right? But your accountant's got to be involved because I can mess up your accountant's life. I can, hey, really screw up your insurance agent when I tell you where to hold your life insurance policies. So I like that team dynamic, but clients are going to each of these advisors and they're saying, well, yeah, we love our kids and we hope that they're going to make good decisions with the assets and we want to leave them in control if they're making good decisions, but we'd rather keep it away from in-laws that aren't in-laws any longer, daughter-in-laws, son-in-laws. 49% of marriages make it. 51% don't, right? So how do you make sure that doesn't all get wrapped up? And a lot of the clients that I work with, have family businesses, closely owned, not closely held companies, not small companies. A lot of times they're very, very profitable companies, but they're owned by a family. And, how do you deal with those kind of dynamics? So to me, it's lazy. It's lazy, either one of those. Hey, I'm going to give it to my kids and just hope they don't blow it all, because you're missing out on a whole bunch of other objective benefits like tax planning and asset protection stuff. And certainly I'm going to leave it to charity, to me, is even lazier. It's saying I've been a lazy parent and now I'm going to be a lazy steward. Right?
mm,
We don't own anything, right? During our lives. We're controlling it. We're stewards of it. And basically you're saying, I don't trust my kids enough to be the stewards over what I'm going to leave them.
mm,
And so again, I don't necessarily respect either philosophy there, but and
mm,
certainly not what I would profess for clients. But I guess I understand give it all to the kids and hope they don't blow it a little bit more.
mm. Wow. Oh, yeah. So where do we go from one and two? We got one and two. What is it that can you give us a few
Well,
scenarios?
I'll tell you what I've done. Okay, and then I can choose any strategy I might want. Right, I'm the car dealer here. I can choose any car on the lot to drive. And even though I might not need the amount of planning that I've done for myself, it's still it gives me comfort and I get free legal work, right? So what just kind of, from what we're talking about right here though, because I have a few layers to my planning, but when something happens to my wife and myself, my kids don't get anything. They get a trust established for their benefit, and that trust will be managed by a board of trustees that I have chosen. Right, people in my life that I would turn to help make decisions. And if you want, we can talk deeper into the qualifications that I feel a trustee needs to have. But these people that I've
Absolutely.
chosen,
Yes.
and make sure I come back to that
Okay.
if you want to go talk, because I'll go off on tangents as you already know this. But this board that I've chosen watches my kids. This is only if something happens to my wife and myself, and I don't have any plans on going anywhere. Very, very, very much the opposite. My wife and I intend on our kids having the Prince Charles syndrome,
Mm,
right? Just waiting for the old lady to die. But let's say something happens to us earlier, and now my kids each get a trust established for their benefit.
mhm,
And it's there for their health and education and maintenance and support and all of sort of the standard things that I'll see in people's estate planning. Or even when people have done it, I typically see that in their trust it'll say, we're leaving it for our kids and they have to be, used for their health, education, maintenance, and support. So the HEM standard. And then at some point in time, usually in these other trusts, the assets will be distributed to the kids at older ages. I still see 25, 30, 35 as some benchmark times. I go out a little bit older, but that's because my oldest is 19 and 25 seems pretty young at this point in time. But he's a good kid. Hopefully I've got time to turn this thing around. But The problem that I have with that is that, while it's great, you're saying, hey, look, usually as kids get older, they make better decisions. And I did. I mean, it was just kind of maturing, and how much a lot of money is to a 25-year-old is a lot different than, what a lot of money looks like to me turning almost 50, right? It's just a different dynamic. And I probably would have made different choices if I had had access to a lot of money at 25 than say I would at my age now. Now that's not always the case. I've met some 70, 80-year-old clients of mine that I wouldn't give a dollar to manage. And I've met clients that are 20, 25 years old starting companies, and I'd love them to manage all of my money because they could do a much better job with it than I am. If I had listened to a lot of my younger clients, I'd be sitting on the boat in the Bahamas right now because I would have actually bought Bitcoin when you could afford it. So, but still, it's like, hey, I don't have all those decisions, and I wouldn't have made all those decisions correctly at the age of 25. So what I do instead is I say, nope, my kids don't get it at 25. I make them actually wait to 30. And at 30, what they do is can control a portion of the trust. They can become a trustee over the trust to a certain degree. I let them control a third at the age of 30. I don't give them a third because if I gave them a third, it would be part of their estate for estate taxes, and it would be available to creditors. They take it, commingle it with marital assets, it gets wrapped up in a divorce, and I promise you it would be taken by a lawsuit creditor, certainly a bankruptcy trustee. But
Mm,
here I let them control it. Now, I don't give them all because even though I want to give them a chance, I want to make sure that these assets last.
mm,
So let's say that my son Harrison, my second, who's most likely of my three kids to do this, he turns 30 years old. He now controls one third of his trust assets. He shows up to the next trustee meeting in a brand new Ferrari. Okay. I don't have anything against Ferraris. I think they're beautiful cars. And if Ferrari wants to sponsor me, I'm in for it. But if he can make the money to go buy himself a Ferrari, go for it, buddy. But if he is using the money that my wife and I have left him to seed his life on buying Ferraris, not only am I going to hunt him, but my board is going to come in and say, guess what, buddy? You blew it. You don't get to be in charge of anything more. And the Ferrari is going back to the dealership.
mm,
Now, let's say he does a great job managing the assets. And when I say doing a good job here, I don't mean he has to take the money and turn it into $1 billion. I mean, he could spend it as long as he's spending it on his health and education and maintenance and support. And then, we go much deeper. We have a 50-page document that talks all about what our core values are and what we're hoping for in impressing those values on throughout our legacy and through future generations. And like one of our core values is entrepreneurialism. I want to encourage that. Yes, I'm a blood-sucking lawyer, but I also, start our firm, and we started COREnology, a spin-off company on our core assets, our core values, thoughts, and so forth. So I want to encourage that in my kids, but I'm not just going to give them a bunch of money and get them to go start a business. My kids, they're going to prepare a business plan, right?
mm,
And hey, they're going to come to the board with that business plan, and the board, who consists of people that I trust, is going to help them with it. And they're going to develop it, and hopefully it's going to be a whole lot better business plan.
mm,
So again, I have much more detail in how that money can be used. But if my kids misuse it, then I have the ability to stop the bleeding and come in and say, nope, the board's going to control the rest. Now, I hope that by the time something happens to my wife and myself, many, many, many years from now, I can look at my kids and think, God, you guys would be great tomorrow at making these decisions. They're just 19, 17, and 15. So I just wouldn't want them to be in that decision-making capacity yet. So I have hope, but that's the way that I'm dealing with it. Now, what that does is it creates this benefit. Yeah, my kids still can enjoy the assets ultimately, after they jump through some hoops, of course, but I like those hoops to make sure the assets don't get squandered. But I don't make it part of their estate. It's generationally skipped from estate taxes. So hopefully they're multi-gazillionaires on their own. I don't want that to be the only thing they're striving for in life by any stretch of the imagination. But if they have that financial success, what I'm leaving them is not going to, at their death, be subject to an additional estate tax. It'll generationally skip it and go on to
very
grandchildren,
important.
and
Yeah.
it's completely protected from creditors.
Mm,
Again, my kids will be the beneficiaries of the trust, nobody else.
mm,
So that's sort of the way that I tell people, look, if you don't trust your kids, I get it. But what about future grandkids or
Mhm.
maybe even existing grandkids? And do you want to cut them out too? Do the sins of the father and the mother really, taint the child? So again, it's a whole bunch of things that you can do. It's getting people to kind of know what their options are because most of my colleagues just kind of do the cookie cutter approach, which is just give it to them at 25, 30, and 35. In fact, I'm going to talk with a client later this afternoon about that exact plan. Very, very nice looking estate plan, well drafted trust. It looks like it was correctly signed in 2024, but what does it do? Exactly what we just said. Mom and dad die and they're worth about $5 million. It goes outright to the kids at 25, 30, and 35. And you say, well, what if you can have the benefit of both worlds? If you trusted enough to give it to them, well, why not just let them be their own trustees of it, and now you protect it from their creditors and keep it available unavailable to the IRS. So a lot in there, probably more than you wanted to know, but that's sort of how my
Oh,
trust is operating.
yes. No, no, actually I loved it. And as you said, there's a lot more to it than you mentioned. But what I'm anxious to find out as well, Andrew, is the 2/3. So what happens? What's going on with that? With your team working, does the team work with that money and continue to see that it grow? I mean, how is that developed? Or I mean, what's going on?
Yeah,
Yeah, I'm not sure.
yeah, not only are they have to. I mean,
Okay.
when you're a trustee, it's a fiduciary position that you take on. And what that means is that you're looking out for somebody else's best interest, not your own, right? If you're the trustee, you're looking out for the benefit of the beneficiaries, not
Hmm.
the benefit of the trustee. And trustees are entitled to reasonable compensation for the time and effort that they put into it. And it's usually not a lot to get rich. I mean, trustees hopefully aren't getting rich because if they are, they're probably doing something illegal. The money is there for the benefit of the beneficiaries.
Of course.
Um, so they're required as a fiduciary to make the assets be productive. Now, a lot of my clients are not necessarily bought into the stock market entirely. Okay. And it's not necessarily it maybe feel a little bit old to them. I mean, we do a lot of research on we work with a lot of financial advisors. In fact, on our COREnology company, it's a software as a service license program for advisors to take their clients through, this discovery process, your core values of the family and what you're trying to build here. But I went off track. Sorry, where were we going on that, Ward? Apologize.
You just wanted to find out how, I mean, how is that other
Oh,
2/3? Yeah.
yeah. So what I was saying is that under the probate codes and the trust codes and so forth, the trustees are required to invest in things that are probably more traditional, like kind of more stock investments types of things, maybe some real estate stuff to a certain degree. But a lot of my clients are into anything from cryptocurrency to doing private money, hard money lending, a lot of various things that clients now do nowadays. And the trustees aren't necessarily allowed to do that without violating their fiduciary obligations. The law says, look, you're putting that money at too much risk. I
Hmm.
think the stock market's pretty risky myself, but they're putting it too much risk other ways.
Absolutely. Yeah.
Now, that is you can change that. You could say, look, the trustees have the option to do a bunch of different things. Like in my case, my kids can borrow to start businesses. Normally, that might not necessarily be the best investment for the trustee to make. And I hope my kids are fabulously successful, but chances are they're going to fail a lot of times. And the trustee, if they didn't have me saying it's okay to do that, it would be a violation of their fiduciary obligations. So yeah, the long answer to your question, what's going on with that money? It needs to be put to work. Now, how it's put to work is again up to the discretion of the trustee under the standards imposed by the trust. Now, again, I have a 50-page document that tells other things that my trustees can do with it, like the entrepreneurialism and things that we want to support. One of the things that we talked about a moment ago was who makes a good trustee, and maybe this will help answer that question.
Sure.
I don't think many people have all three of the characteristics that I think a trustee needs to have to do a good job. And the characteristics are this. You want a trustee that is well organized. There's a lot of moving pieces that go on when you finalize an estate, and that's even in the most simple of an estate. most of my clients don't have the most simple estates, right? Privately held companies, real estate all over the country, whatever it might be. And you want that trustee that can keep track of the appropriate expense and make sure that it's getting paid for out of the appropriate account. I mean, if you don't have proper maintenance to these strategies and structures that we put into play, they always fail. Nobody is organized anymore. We all think we're organized, but if you take my smartphone away from me, I'm pretty stupid the next day, right? Okay, so this the second characteristic of a good trustee is you want a good decision maker. But when I say that, I don't mean you have to go convince Warren Buffett to be the trustee of your trust. In my mind, a good decision maker these days just says, look, some issue has come up affecting the trust or maybe one of the trust assets. And maybe that's a tax issue. Maybe that's a legal issue. And this trustee isn't an attorney or an accountant. They don't need to be. They can hire the attorney or the accountant. And you want them to so that the best decisions are getting made, right? And then finally, I'm leaving these assets in trust for the benefit of my kids.
Mhm.
And I think it would be great if I had a beneficiary that also knew my kids. Now,
Mhm.
my wife and I just didn't have that one person in our life that was well organized, a good decision maker who knew our children. So, what we did is we named this board. And on our board, each of the people that we chose brings one of these benefits to the table. Like the organized guy, that's my law partner, David York, the most well organized human being on the face of this earth. The only thing this guy thinks is better than one spreadsheet is two spreadsheets. Great. Bring that to the table. Second person I have on there is a friend of mine that is financially minded, at least similar to how I think about the financial world. And I know he would travel throughout the country, maybe the world, to get advice from the best people possible on issues affecting the trust. He's not the most well organized. I don't know if he's actually ever met my kids, but I don't need him to. And then finally, in my case, two of my kids are still under the age of 18. And if something happens to my wife and myself, there'll be a legal guardian, right? This poor soul that has agreed to take custody of my little hellions and raise them and love them and nurture them. And I have left money to do that. Well, I want them to have a say in how that money's being used. So they're going to play that third role. And I have the board making decisions by 2/3 majority vote. I
Mm.
think there's a few other ancillary benefits to that. Number one, being a trustee is not a fun job. And, a lot of times I'll tell clients, make sure you're asking the people here that they're willing to do it. And you're going to find something interesting. They're going to come back and feel flattered. Thank you so much for thinking of me. You must trust me and so forth, right? But dig a little deeper and you say, hey, look, this means that you could be in charge of what could potentially be a lot of money until my kids reach the age of 30 or 35, 40, whatever it might be, maybe forever. I have
Mhm.
plenty of clients that say, I never want my kids to control what I'm leaving them.
Mhm.
So, what I like about the board is the burden, if you will, of being a trustee just doesn't fall on one person's shoulders,
Mhm.
right? They can divide and conquer and all those classic cliches. I also mentioned earlier that it would be illegal. I mean, literally illegal, criminal behavior for the trustee to use the money in the trust for their own financial gain. Okay. It's illegal to kill people. Doesn't mean they don't get murdered, right? Doesn't mean that it doesn't happen. And I like the checks and balances that go on here. I like that two signatures are required for any check. And yeah, maybe that slows the wheels down a little bit more, but if I'm not there, that's fine. Let it slow down a little bit. If it was a decision that had to be made that quickly, probably wasn't a decision I was going to make anyway, right? So I don't mind if it slows down a little bit. I also have this revolving line on my board. I don't have to look out 10 years from now, 5 years from now, a year from now, and try to determine in my life who's going to be willing and able to be a trustee. Right. If one of my board members dies, becomes disabled, whatever, well, the two who are still, acting can appoint their replacement. So I always have this revolving line. So that's the way, my wife and I have kind of set up that advisory board. And again, I hope that my kids have, great decision making capabilities and can be their own trustees. We just got some time to tell.
So ultimately, they do become complete trustees of the entire trust.
Yeah, let's say everything goes well. Harrison doesn't buy Ferraris. He manages everything. He does a good job. Then at 35, I allow him to be in charge of another third. And by the time he's 40, and all my kids, I do it the same way for all of them. By the time they're 40, they can be in charge of everything. And I hope that's the case. Again, if they do everything well in those stages, but what I don't want to do is say just give it all to them at once.
Yes.
Now, even if, clients that say to me, Andrew, my kids are adults, have families of their own. And I say, okay, fine. Leave it to them in a trust for their benefit that they control 100% of day one. That's what my mom does. My mom passes away. She leaves a trust with half of her estate to me and in a trust for half of the estate for my sister. We get to be our own trustees, right? My mom has this crazy notion that I know how to run a trust, right? So that's what she said in her plan. Now she also has me as her lawyer, so I've done her planning for all of these reasons. I'm not completely altruistic. I want to enjoy what my mom leaves me, and by leaving it in a trust for my benefit, I'm the trustee of that trust. So the assets are not a part of my estate, not available to creditors, but I control the whole thing. If I
Mhm.
want to pull something out and give it to the beneficiary, I'm writing myself a check. But it's not part of my estate for estate taxes, and it can't be taken from me by a creditor. I have yet to find a downside in doing it that way. And I think more and more people are, but I still see, I would say 96, 98% of even the trusts that are done, like the one that was done last year for this client I mentioned earlier that I'm going to speak with, still makes outright distributions.
Mhm.
So I just don't see a need or a reason to do that. I mean, if I was a child and I had my choice, and I've done this for my mom, so I am in this position. If I say, hey, mom, leave me a $5 million in cash and just leave it on the doorstep and hope that I don't lose it. Or let me control an account that has $5 million in it that nobody can ever take from me. What would most people choose? To me, the latter is the better because it's not at risk, but I could be a little bit more risk averse.
Mhm. Now, for those that are listening, I know that they're probably not privy of this information that I'm about to share, and so I want them to know a little bit more, even more about who Andrew Howell is, and so by
Wait
doing
a
so,
second. We're not going to talk about my criminal background, are we?
you
Do we
too.
have attorney-client privilege, Ward? You're not supposed to divulge anything.
Okay, so you have done extensive work.
David and I, my co-author on our book and co-part founder of our firm, what we've tried to do is model how we encourage clients to do their estate planning under what we would call the Rothschild method. Some
Okay.
people would refer to it as the Rockefeller method.
Mhm.
In fact, in our book, in our first book, Entrusted, we give the story of the Rothschild family and how it was all built. But the Rothschilds, they look at their family differently. And this goes way back to Meyer Rothschild in the late 1800s or late 1700s. And what he did is he encouraged each of his children, really his sons, was a little patriarchal back then, to go and build their own banking empire in the various hubs in Europe. And but it was still all a family business, right? Our My wealthy families, they don't divide assets. They don't just say, "Hey, look, we're just going to divide everything up and everybody gets a piece of something," because that just diffuses everything. You lose all of the wealth, the power. I mean, you take the Rothschild family, the Rockefeller family for that matter, they hold everything together. The companies are still there and maybe it's diffused ownership through trusts, and I have some knowledge about what the Rockefellers have actually done, but that's private as to why, but it's
Right.
not exactly what people profess it to be. It's again more the Rothschild because what Rothschild did is he said, look, I put a big investment into each of these assets of my family business, the kids, however callous that might sound, right? I don't think it's callous because raising kids, they're expensive, man, right? You make a significant investment in it. And this is kind of going down the path of buying life insurance and so forth and family banking concepts. And again, people call it the Rockefeller method. But what he would do is he would say, look, if I lose one of these investments, they pass away. However tragic that might be, of course, emotionally, I've lost a significant investment. I'm hoping that these next heirs, they're going to benefit the entire family. They're going to create a legacy. A lot of times my clients are worried about what their client or what their kids are going to do with it. His expectation was they're going to do something with it. And if I am making that big of an investment in you and I lose the investment, how am I going to recoup my losses? And that's where again, you buy life insurance now, and that insurance is really tax efficient and comes income tax free to the beneficiaries and all of the amazing benefits to insurance. And I'm not selling insurance. Just want to make this clear. No hopes of a commission, right? But I am a big fan of insurance because I do think it has a lot of benefits to it. And my wife would tell everybody on this call and maybe all the hitmen that she's already contacted that I'm worth more dead than I am alive because I got a lot of life insurance. But all of those things need to all be coordinated in general for the family holistically, not just paying total attention to the tangible assets, the money in the bank, but you've got to first understand why are we doing all of this? Because if a family is charitably inclined, right? Let's find out that generosity, or let's say that the family comes to me, I've got their report, I know what their values are, and that one of their collective family values is charity, some sort of charitable intent. Well, as a tax attorney, I can leverage that now. I can do some tax planning with that. We can structure their planning in such a way that they get the charitable benefit, but we also keep it out of the arms of the IRS. And so you can have the benefit of both worlds. But I need to know that because I need to know what I can leverage. I always tell people charitable giving, you're not usually better off just by giving to charity. It's usually better just pay the taxes, you grow more money in the pot in your pocket. But if you do have that charitable intent, then we can get a tax benefit to that. And I need to know how I'm going to structure their estate plan. So again, probably just dumping a bunch of stuff out at you
No,
here, but
no, no,
it's
no
a
way.
long-winded way to say that you've got to look at it in a much more holistic way.
Mm-hmm. Yeah, so that case in point, I mean, I use the Rothschilds also because there's a difference between where they are today based on my Rothschild, and what the Vanderbilts actually did. Can we talk a little
Oh
bit?
yeah. Yeah, Cornelius Vanderbilt. We actually we talk about this in our book as well. We have a whole presentation on this. In fact, my law partner David did a TEDx talk on this topic. It's
Mhm.
like 10 minutes long. It's a great watch. I think it's called the $30 million tsunami or the $40 trillion tsunami. And the
Yeah.
point of that is, and it's actually gone up now, it's anywhere from 70 to $90 trillion is going to be changing hands over the next 30 to 40 years. It's the largest wealth transfer in human history, and it's almost entirely all unharnessed. And our true belief and hope is through things like COREnology and putting more purpose in this, that families can get over that shirt sleeves to shirt sleeves in three generations conundrum. And so yeah, I know I went off topic there. What was your first question? I apologize, Ward.
No, no, no. I just wanted to like compare the actual uh, Vanderbilt
Oh yeah.
situation
So
versus.
Cornelius Vanderbilt, right, when he died, he was the wealthiest man in the entire world. Probably equivalent to what Elon Musk is right now. He was estimated to be in today's dollars $185 billion. Okay. So 30 years after his death, because their estate plan was very much divide and dump right onto that next generation, and they're notorious spenders, right? I would say they were the Kardashians before the Kardashians were cool. But the issue with the Kardashians is they make the money, right? These kids weren't making the money. 30 years later, there was not any of the Vanderbilts that were amongst the top net worth people in the entire country. Okay. Now they were still wealthy at that point in time, but 100 years later, there was a Vanderbilt reunion, a family reunion at Vanderbilt University. And everybody that showed up, not one of them was a millionaire. I mean, it was just gone 100 years later. And it was just because they took the approach of we're going to divide it, we're going to dump it, and just hope that it doesn't blow up in everybody's face.
Mhm.
So yeah, it's a sad tell. In fact, really the only asset, which is only it's an incredible asset, but there's this hotel that the Vanderbilt family still owns, the Biltmore, and that family still controls it and so forth. But that's about it in terms of their wealth.
Mm. Yes, and the difference between the two, I mean, one used, I mean, like you said, you're not a life insurance salesperson, but um, that's what the Rothschilds did, if I'm not
Well,
mistaken.
yeah, and that's what that's what, as I understand it, that's how they're doing it now. How they did it back, I'm not going to profess to be any kind of expert back in the 1800s, what people were doing in terms of investing and insurance and all of those various kind of things. But he was definitely investing in his family, and he was also creating accountability within his
Yes.
family.
Hmm.
Like me, he didn't just give his kids anything. What he did is he set them up, right? I'll give you a loan, but the family's going to own the bank that you're setting up. I mean, arguably, the estimates is that family controls up to two to $3 trillion right now, just them, just themselves, and that could be a low estimate. So it's again, we're not giving up the asset. We're going to allow everybody to benefit in some way, but we also have expectations. We have accountability. I mean,
Hmm.
I we say this all the time in our families that successfully navigate this. I think they're able to express three clear expectations for every member in the family.
Hmm.
And what we say, each member of the family has to know what they can expect from being part of the family.
Hmm.
What's the benefit? Right?
Hmm.
Otherwise, why do they care what mom and dad says, right? And this is a really poor example, but our family, we have a place up in Southwest Montana, small ranch that we love to death. And our family knows that if they go up there and they take care of it, they take their friends and they're responsible, they leave it cleaner than they found it, all that kind of stuff, they get to use it. Okay. Doesn't cost them anything. And anyway, dad makes all of their friends sign waivers of liability, right? But that kind of stuff. But they get that's a benefit, not the greatest example, but they also need to know what they cannot expect from being part of the family, right? Just because dad's successful, that doesn't mean you are. And you're not going to sit on the couch and eat bonbons. You
Learned
you
that at a
need to be
very
so,
young age.
you need to be self-sufficient, right? And my kids know this. They know that at some point in time the gravy train's going to stop. And that's important. And they need to have three things, I think, in life to be happy. You need to have somebody to love, something to hope for, and something to do. And I encourage that within my kids, right? I want them to find their romantic partner. I want them to have something professionally to do in life. Whatever that, I don't care if you're a plumber. If you love fixing pipes, be a
Well, yeah.
plumber. One of my largest clients owns a huge plumbing company. Wonderful. Do it. But you're going to do it, right? And you're going to put your effort into it. And then they need to know what's expected of them. Right? That's the third expectation. What can they expect, what they can't expect, and what's expected of them. If you
Hmm.
want to be part of this family dynamic, how are you expected to plug in?
Mm.
How are you going to participate? And some families have members of the family that don't.
That's
And if
right.
I have a member of my, now luckily all three of my kids do right now, but let's say they have a wife that comes into play who doesn't want. And I know this is all touchy-feely BS and values. What are we talking about? All this stuff. I don't want any part of that, right? Fine. You don't
Okay.
have to. You don't have to participate in it. You don't get a benefit, but you don't have to
Okay.
participate, right? So, um, but yeah, I think there's again so many different ways to look at it, and what's important about the core value discovery process is that it tells me what yours are. It tells me what your families are, what every member of the families are. I don't know if we talked about this last time, but if you and I were to compare our core values, there's a 1 in 15 million chance that you're going to have the same core values, top five core values as I have. And it's because we've had different life experiences.
Mhm.
And like one of my core values, I don't give this as an example and nobody believes me, but it's true, is honesty. It sounds dishonest coming from a blood-sucking lawyer, but I mean that. And it's because early on in our family dynamics, there was a member of our family, let's say, that was pretty dishonest. And it's caused issues within the family that in some ways maybe we're still dealing with today, right? So and so doesn't want to sit next to the other person at the Thanksgiving dinner table, right? So if I'm sitting down and I'm, explaining to my kids, I have this core value of honesty. I'm not being preachy. Right? I'm not saying, Thomas, who's my oldest, shame on you. You were so dishonest last week. I'm just saying it's important to me and why. And I'm teaching them family lore. Right? And why the dynamics are such at the Thanksgiving dinner table. But I'm also teaching them about me, how to deal with me, maybe. I mean, they wreck my car. I have insurance. I'm going to be unhappy, of course, but if they lie to me about it, dad's going nuclear, right? So who am I? And then who are we as a family collectively as our core values? And now my board of trustees has that as their direction. They don't necessarily have to invest in the stock market unless they feel that's the best investment. They can invest in my kids, right?
Mhm.
They can invest in making business loans. I treat my family as in a business and those members of the family assets of the business. And I need them to be stewards of it. My law partner David, he wrote a great book called The Gift of Lift, which talks about stewardship, and I'm a huge fan of mentors. You ought to have a mentor in your life, regardless of what chapter in your life you are. And I'm always trying to seek those out, and I find that as a common theme throughout my life. And so I see that I'm a steward, I'm a mentor for my estate right now, and my biggest goal, at least where I am in life right now, is trying to prepare that next generation to receive the wealth.
Mhm.
That's another one of our principles in Entrusted is that entrusted families, they prepare the next generation for the wealth, not just the wealth for the next generation. And just so much financial planning is the opposite, right? We're going to just bundle it all up without any consequence thought and just give it to all the kids. And so anyway, again, there's a completely different way.
Mm. Agreed, man. That's so powerful. And the thing of it all is let me ask you this. Is there a chart, some type of charter or chart that you can kind of steer those that are interested in uh the Rothschild way of creating generational wealth, if you will? Is there something that they can kind of like you can kind of point them to that you may know of?
I probably have a flow chart that I could pull up and share if you want me to. I always worry just a little bit about doing that because what I'm now doing is the exact opposite of what I like to do. I'm just throwing a bunch of tools and techniques and do a trust in Nevada and do an LLC in Wyoming and all of these
I
various techniques that we
understand,
try to
understand,
utilize
understand.
without first knowing what a client might actually want to accomplish.
Totally understand that.
Um, so normally, yeah. So I normally I wouldn't do it. Is there a way that I can share my screen?
Oh, absolutely.
Let's see. I think you need to make. I'm going to come in on a different device too. I use iPad. Sorry, Word. I should have been prepared for this.
No
You're
worries.
going to see me coming in. It'll just be my name.
Okay.
Work technology. No audio. And then if you could give me co-host,
You
then I can share my.
you should have it.
All right, hang on. Okay, I'm going to change screens on everybody.
Yeah.
Um, you're going to see a couple of things pop up.
Yeah.
All right. So this is an example of a flow chart that I put in play for a client of mine. I've tried to scrub it, of course. This is John and Jane Doe, but in their scenario, this guy owns an operating company set up as an S corporation. He's got a partner in it. They own it 50-50. I'm a huge fan of buy-sell agreements when it comes to partnerships. I always tell people to treat partnerships as seriously as a marriage because you're getting legally bound to this partner. And we talked earlier, 49% of marriages make it. 100% of partnerships end. So making sure that you've got that prenuptial agreement in the partnership, which is the buy sell, right? What if a partner dies, becomes disabled? They don't want to be partners any longer. So, we have some ownership there. This is a professional company as well. So he owns it directly for some other reasons due to their insurance and so forth. They then have another company that they've started, which is a software-based company. We have it set up as a C corporation in Delaware. Number of reasons for that, well beyond this call we're having today. We've got that set up as a C corporation, which normally isn't the most tax efficient way to do it, but they really think that there's going to be a long-term exit in this company. They're going to sell it for millions of dollars. And there's some qualified small business stock or what's called 1202 tax planning that we can do with it. Again, I think well beyond what we're talking about today.
Mhm.
But in terms of your question, where do we hold all of their legacy assets? It's underneath this LLC, this Family Enterprises Company, LLC. And I love Wyoming for a number of reasons. You hear Delaware, Nevada, Wyoming, and we just talked about Delaware for C corporations because I think they have the best corporate laws. But when it comes to LLCs, I love Wyoming. Wyoming was the first state in the nation back in 1977 to authorize for this new form of entity called the LLC that we all now use extensively. And it's funny to think of Wyoming on the cutting edge of anything, but they've always been on the cutting edge of LLC law. But it's also really protective when it comes to charging orders. Right? Let's say something happens and I sue John here for some reason. At most, after years of litigation and hundreds of thousands of dollars in legal fees, chances are I won't do this, but I sue him and I win. What can I get here? I can't get the underlying assets. He doesn't own them. What he owns in this case is a 1% interest of the LLC. And
Mm.
under charging order rules there in Wyoming, if the LLC ever distributed anything to John, I would be able to take it. So the LLC doesn't distribute it to John. It goes to Jane, or it might go to this legacy trust that we'll talk a little bit more here in just a minute. So we get some great protection there in Wyoming. They have an LLC that owns some property they have in Florida. They own a ranch up in Montana, actually kind of close to where we are. We have that in a Montana LLC. He's got some intellectual property that he owns separate from this company that he's created, that they've kept it separate and have some licensing things that go on. And then I have an LLC set up for him, and I do this myself in my own planning, and it only owns those zero liability risk type of assets. Right? I could go on this guy's property in Florida, slip and fall and injure myself, but if it's an LLC in an LLC, I get to go after the LLC because it's the owner and the equity in that property, if there is any equity. And there's ways to strip out that equity. But if there's any equity in there, but I'm not going after John personally. It's the issue though with like your cash, just because you have a bunch of cash, you're not going to get sued over it. I guess a dollar bill falls out your pocket and the guy behind you slips on it. Maybe he's going to sue you over your cash, right? But I can't envision any other of those kind of things. But I also have life insurance. Why? Well, I have a lot of life insurance on myself. We got a lot on my wife. Our kids all have policies. I don't want to have to worry about various owners. There's one owner, the LLC. So I know every time I need to pay a premium, it's going out of the LLC account. The beneficiary is also the LLC. Why? Well, again, that death benefit comes into the family bank. We're going to treat it like a bank. Borrow money to start a business. You're going to come back and report to the family bank about what you're doing with it, encouraging that entrepreneurialism. So that's what I'm doing to help clients structure this kind of Rothschild, if you will, or again, a lot of people say Rockefeller method. Now, the reason that I'm really doing this is to try to deal with the erosive effects of wealth transfer. I mean, objectively speaking, why don't these generational wealth go beyond 3 generations? And it's because of these 3 erosive effects. Number one, the division of the estate, right? You take a client that's worth $100 million, and let's say they have 4 children who have 4 children who have 4 children. By the time the money, just from division alone, gets down to the great grandchild, I don't know if people watch this, they'll probably grok it or Google it or whatever, right? But everybody's getting just north of $390,000.
Mm.
And you can't do with 390,000 that you can with 100 million. So you lose the power of that money, right? Like we were talking about before. These wealthy families, they hold things together, family businesses. People say don't do business with your family.
Yeah.
Really? I mean, how could you not want to do business with your family if you could? Now, don't get me wrong. I love my sister to death. I don't want to see her on a daily basis though, but I do think that it's, when my mom passes, we're going to, whether we like it or not, have to manage family assets together. So
Hmm.
it's going to happen. If you want to keep your family together, you should encourage that. How do you foster that and not shy away from it?
Love it.
But now let's say something happens in this case, John and Jane Doe here, and let's say that their LLC has 100 million in assets. Well, what happens at their passing? Well, just like my kids, their kids don't get anything outright, right? Bobby, Susie, and Joey here, of course, not their real names, get a lifetime trust. And what will that trust own? It will own 1/3 of the LLC. So the 100 million is still owned by the LLC, and yeah, they each own 1/3 of it. Again, that's what the Rockefellers, that's what these large families do, is they give ownership of the company away, not the company assets, right? Or the family business assets. Now, estate taxes, that's another erosive effect, right? And under current law right now, this is why I can have this presentation as 14 million plus. Under current law, which is the Trump tax reform, everybody at their passing or during their life could give 13.99 million away tax free. That's at the federal level. We're not going to go into state death tax because some states have it, but it would be too
Mhm.
boring for everybody who's probably already bored already. But if you got a married couple, it's close to 28 million that you could leave your children at your death entirely tax free. Most people do not have an estate tax at its current level. I mean, most people are in debt, let alone having pies and it no worse of $28 million. But this law is going to change, and how quickly it changes, I don't know. Things live on the internet forever, so I have to preface this that we are now in May, right, of 2025, and it's undecided what's going to happen. At the end of this year, the Trump tax reform is set to expire, and we're going to go back to what the law was under Obama, and that'll mean about half as much, 7 million per person or 14 million as a married couple that could pass tax free with a 35% tax on anything over and above it. Now, if I were a betting man, which I'm not because I hate losing money, but if I were a betting man, I would bet that the Trump tax reform is going to get extended. Or it might be something like we had with the Bush tax cuts back in 2011, 2012. If you remember, there was this fiscal cliff debacle. The Bush tax cuts were going to expire and we were all going to end, the world was going to end. Now, we fell off the fiscal cliff for one day, January 1st of 2013. But on January 2nd, they passed a law fixing everything. And it won't surprise me if something like that happens this year with Trump, but I do think it will ultimately be extended. But 4 years from now, there's going to be another political circus, and 4 years from then, and this political pendulum of Republican and Democrats going to swing back for the rest of our lives. And you're kind of taking a gamble on when you die. Now, I don't like that. I'm a big fan of planning, right? I'm an estate planner, and I think that you do a lot here in taking control of your own destiny. Right? With the planning that we're doing here, we're taking control of what we think the value of the estate is worth, not what the IRS thinks it's worth. A lot
Awesome.
of people don't realize this. When you die, the IRS will determine the value of your estate if you haven't done it yourself. And their determination of value might be a lot more than yours, right? You have a closely held business that's making a lot of money, right? Even though it might feel like at the end of the day, after you pay all your bills, you didn't have much left over. But because of how much that money the company was actually making, and you run it through these multiples by EBITDA models, right? You might be a whole lot wealthier than you actually think. So, and those small business owners, as well as real estate holders, aren't also aware that the estate tax is owed to the federal government 9 months after you die, and it has to be paid in cash. Right? The IRS does not accept real estate. They do not accept business interest. So you have to sell businesses, you have to sell real
I
estate
used
within
to,
nine
yeah.
months.
Mhm.
You're getting fire sales, right? So how do we solve this estate tax issue? Because if every generation's taking a 50% haircut, it's going to get eroded away. Well,
Mhm.
in this case, in the planning that we've done for these guys, they don't own really anything here. They have 98% interest that they've given away, or really they've sold it to the trust. And we'll come back to this trust in just a minute. And this trust, back, maybe we ought to talk about it now. Let me explain what this is. Prior to 1997, if you wanted to do a trust for your own benefit or that of your family, your wife, whatever, and you wanted to get any kind of asset protection planning from that trust, you had to choose an offshore location. You had to go to the Cayman Islands or Switzerland or do something like that, right? And you had a lot of people that were doing it for asset protection planning reasons, like we're talking about now.
Mhm.
They were also doing it for tax evasion. Now, you can't do it for tax evasion any longer. The US knows about your worldwide assets, but from an asset protection standpoint, it still works.
Mhm.
Offshore locales now that we use are typically more like the Cook Islands, or I prefer Nevis to do it, something like that in. The problem, though, it involves a lot of money in legal fees. It's really complex to do it the right way. You're moving your assets to another country, and they'll be under the control of some trustee in Nevis. So what happened in 1997 is Alaska, which was the first state in the nation to allow people to do this. They said, nope, we'll allow people to do this domestically. You can create a trust like this, do it in Alaska, put your assets inside of that trust, if you keep your nose clean for 3 years, because there's a 3 year look back window, but after 3 years, if creditors haven't come after those assets, the assets are forever protected from creditors.
Mm.
Now, Nevada came along not too close after Alaska adopted it and said, well, we want to do this as well, but we're going to one up Alaska. And we're going to say, look, if you create your trust in Nevada, you only have to keep your nose clean for 2 years. So one less year. Now, Nevis and St. Kitts and some places that I like to do it, even offshore, you still have to keep your nose clean for 1 year. But now you could basically get the same benefit, keep your assets stateside under the control of somebody that might not be in Nevis. And it was this, new idea. And it was dramatic, a big change in how American law was done. And we call this the Domestic Asset Protection Trust. I do like Nevada. That's where I've personally done mine. I think they have some great case law in Nevada that backs this up that most states don't have. So I like it for that reason. But what happened here is, in this case, John, who's the grantor of the trust, the creator of it, created it for the benefit of his wife and his kids. Now, he could be the beneficiary again if he needed to through some legal maneuvering, but that would really only be if Jane runs off to the Bahamas with the pool boy, right? If they're going through a divorce. Because as long as they're married, I don't like him to be a beneficiary. I mean, first of all, for IRS tax purposes, they ever try to say this was part of his estate, we say, no, he wasn't even a beneficiary. And if I ever tried to sue him, not only is it an asset protection trust in Nevada, he's not even a beneficiary. So he's sort of doubly protected. But now Jane can be the beneficiary. And then through a series of transactions, the LLC is owned 98% by that legacy trust for the benefit of the family. Now, what that means is that 98 million of value is not part of their estate and
Mhm.
won't be part of a state tax consideration.
Mhm.
So that's another benefit to this structure. And then the misuse of the assets and the creditors, right? We talked about this before. Well, just like my kids, his kids will not get anything outright, right? They get a lifetime trust for their benefit, managed with a 5-person board that he chose as a board of trustees, who's also going to manage the family holding companies and various things. They have really a private trust company that we've done in Wyoming. I don't, There's already enough boxes on this diagram. Now, I want to make this clear. To everybody viewing this, I don't believe that he who dies with the most LLCs wins. I mean this. I think that every company, trust, whatever needs to have a business purpose. And that's why I was saying kind of hesitant to share this. This is what these guys have chosen as their structure to solve their complex issues. But their creditors won't ever take it from the kids. Their family's gone through our COREnology process. And so we have their report attached to their lifetime trust. So their 5-person board knows, what the core values are and what are the things that they would be willing to support. So that's how we hope to protect against the misuse of those assets. So that's the structure in terms of a sort of, if you said, Andrew, what would a Rockefeller, Legacy, Dynasty, Rothschild sort of structure look like? This is typically what I have my clients into.
I really, really thank you for doing that, Andrew. Really, really. Uh,
Yeah, but I'm not giving legal advice, right?
right. Exactly.
No,
That's
I think I
awesome.
make light of it, but it is important because there's so much out there. The information age is amazing because we have everything at our fingertip, but it's dangerous because we have everything at our fingertip. And I talk to clients all the time, and they're great self-learners. They're educating themselves. I read a ton of books. I don't read a lot of books actually. I listen to them because I can't. By the time I get home, I don't want to read anything else anymore. But I listen to a lot of books and I try to learn myself. But the problem is with all of the information, it gets confusing. And they'll hear one guy say, do an LLC in Wyoming. They'll hear another guy say, do it in Delaware. They'll have one guy say, do an LL or do an asset protection trust in South Dakota. Another guy says, does it in Nevada. Do, land trusts is the big thing I'm hearing again.
Yeah, right.
Every 10 or 15 years, this land trust
Right.
debacle gets
Yes.
recirculated to me. And I'm like, no, there's just so many better ways to do it. But anyway, it's just what I need to do with a client. And everybody that listens to this podcast or watches this podcast, whatever, you should demand this from your advisors. When you go in and you meet with your estate planner for the first time, and only 30% of the population ever does this, so there's probably going to be a large section of your listeners that haven't done it. When you go in, you should demand that they ask a lot of questions about you and your kids and what your goals are, not just hit you with a bunch of tools and trusts and Nevada and all of this kind of BS. This is this is a toolbox, right? All of these tools here that I can use, but I got to know what I'm building, right? I got to know what you want me to create. Otherwise, it's me doing your estate planning for you. I have a client that I've been working with now for like 6 years in the transition of a family business. And they have literally said to me in meetings before, Andrew, you tell us what to do. No. First of all, I'm not the beneficiary of it, so I don't want to take on that kind of responsibility, but it's not up for me to say. I am not the steward over your stuff, you are.
Yes, sir.
So you get somebody that can engage in that kind of a dialogue, and you need to demand it, not just of your attorney, but you ought to demand it from your accountant, from your financial advisors, from your insurance agents. I mean, our clients will take their COREnology report and they'll give it to all of their advisors, and they'll say, "Look, this is us. Read it and learn about us before we meet."
Thank you so much for coming in and doing that part two. Now, I think people have a great uh, perspective on why I wanted you to come back and do this some more. And I know you have tons of other information to share. The Wealthy Dentist podcast is built on connections, opportunities, and meaningful conversations that help jumpstart careers and boost the ROI on your business. Is there a topic you're passionate about or someone in the dental community who should share their story with us? We want to hear from you. Email your suggestions to the Wealthy Dentist Podcast at gmail.com, and let's create content that informs, inspires, and uplifts the dental world. Your ideas could spark our next big conversation. Let's make it happen. I'm Ward Powell, your host at the Wealthy Dentist Podcast, thanking you for being a part of our journey.